Welcome to ThePrint. India's fight against corruption has been a long and arduous battle that has been fought with a plethora of laws. One such very important law is the Prevention of Corruption Act, which was of course introduced to curb corruption in the country. Now, what does this law say and how efficient has it been in achieving its objectives? We'll find out in today's episode of Laws of the Land. For this episode, you have me, Apoorva Mandhani. We have with us Bhadra, Sinha, and we have with us Supreme Court lawyer Prachi Pratap with us. Thank you so much for joining us, Prachi.
Thank you.
Thank you so much for joining us, Prachi. So the first question is, why was the need felt to have a law to combat corruption?
So just going back to the origins, it was established, the need was actually felt during the time of Second World War. When there was an increase in demand for war materials and there was a decreased supply, that's when the corruption started. So that's when the need for the law came. Then we got the law in 1947. Then there was the ThePrint committee, which did some amendments, and later the Prevention of Corruption Act came in 1988. That was just to ensure that the public servants are not earning anything beyond the legal remuneration which is given. Because there were instances of getting money had started to pop up. It was not as much prevalent as it is now, but that is where the need to amend the act and to make it more structured, not to replace IPC, but to help IPC. That's why it came.
So it was like a law. So do we have any provision in IPC to combat corruption? And was it felt that it is not sufficient?
It was felt that IPC was not sufficient. There was the Snatam committee report that suggested that there needs to be something that helps IPC.
Okay.
Because IPC was basically criminal oriented, and we were talking about corruption. And one beauty of the act at that point when it came was it did not mention the word bribe. It just said undue advantage.
Okay.
So that was undue advantage could cover a plethora of things.
Okay.
So that gave, a strict policy for covering those public servants, the special judges which were there, the ambit of the act. So it needed to be carved out separately from IPC.
Okay. So then what was the framework or the design of the Prevention of Corruption Act? It turned out to be an exclusive law, right? As you just mentioned.
Yes.
So what is the framework under this law? Do we have special agency to handle it? Do we have special courts to handle it? Special prosecutors? So how does it go about it?
So you start with this, for filing a complaint or for investigating, most importantly, it is prescribed that who will investigate in a metropolitan area, who will investigate, say, in a metropolitan city, it has to be an assistant commissioner of police who can investigate. City like Delhi, an inspector can. So first it said that you need permissions to investigate. Then who can investigate? Which court is it going to be trialed? Which permissions do you need to try against a public servant? So it kept developing as and when the need came. And it gainfully described how or who all are covered under public servant, government officials, whoever is receiving, say, money, remuneration from the central government will be covered.
Right.
However, the commercial part of it excluded charitable trusts.
Okay. Can you just explain it a little bit?
So there will be commercial organizations who are, say, semi-government organizations who will be covered under, say, Prevention of Corruption Act. However, if it's a charitable organization or a charitable trust which has government link, then you have to go into the fine nitty-gritties of it to figure out if it is covered under Prevention of Corruption Act or not.
Okay. So which means what you're trying to say is that the law also provides for some separate set of provisions to deal with charitable institutions that are working with the government.
Right.
Okay.
Absolutely.
So as you said that, you have designated officers.
Right.
So do we need a specialized agency to investigate a corruption case under this particular law, or can a state police also conduct a corruption?
State police can also do the investigation, as I said, and of course vigilance officers are there. So yes, it needs specific depending upon who is being trialed.
Okay.
It's not that just anybody can be tried by just the police or just by the vigilance. It depends upon it, and that's what has made it more complicated and led to further amendments in the Act.
Okay, that I think we can touch upon a little bit later. But so to start with, how is a public servant defined under the law?
So public servant will be any person who is getting remuneration
Right.
from the government.
Okay.
State, central, whichever. It will also be the other agencies, say somebody is working at the block level, or somebody who's, as they say it in Hindi, samvida, somebody is on that, they will also be considered public servant because their remuneration is flowing from the government.
Okay, so would that also include politicians?
Politicians are covered under it.
Okay, okay.
So
Now, is there a
definitely.
procedure prescribed? So, if suppose one wants to prosecute a public servant under PCA, what exactly is the procedure prescribed in the law?
Also, since just to add to that, since you also mentioned that it was brought in to sort of supplement the provisions in IPC, so how does that work? So if a public servant is supposed to be prosecuted for corruption, what sort of provisions, IPC provisions, are applied to them along with Prevention of Corruption Act
Yes, that will be there because the charges are often framed, say there will be it might be a charge under 420 IPC. Then there might be, say, misappropriation of property. So there are different parallel cases that will be registered under different acts along with Prevention of Corruption Act.
That can be done. That can be done.
Prevention of Corruption Act is under which a public servant will be booked. Because otherwise, just under IPC, it will give them certain, immunity.
Okay.
And Prevention of Corruption Act kind of brings out that shield.
Okay.
And makes them answerable to the public. So, in fact, there was a very nice judgment in 2000 game, State of MP versus Ram Singh, which said that it is a social legislation. It should help, it should not amplify the accused, but it should not even protect the accused. It should be very balanced.
Okay, okay. So can you just talk about the procedure? So suppose I have gone and complained against somebody and I want that person to be prosecuted under corruption. So is there any specific procedure laid out which an agency has to follow?
So for that, see, different organizations have different setups. Say banking, it will be the ombudsman you will approach to, and then they will tell you who to go through. For regular corruption, you can go to, you don't have to just go to, say, the authorities in that government department. You can just go and lodge an FIR or just a complaint, forget that. And it will be turned into FIR because, again, I'm going back to the amendment, which kind of clarifies it is, say if X gives, graft to somebody. So if he goes and complains within 7 days to the police, he will be safeguarded from giving the bribe and the case will begin.
Okay.
So those are the procedures. It makes it easy for you to complain. You can just send an email to to whichever department it is that you have.
Right.
Or if it is against, say, a politician, you can just go and put a complaint, in, say, if it's related to a certain department they are in, ministry or something, you can go to that ministry, or you can just put a police complaint and then action will be taken.
So a direct police complaint can be initiated,
that
right?
can be.
Okay, and then there is a provision in the law which says that you need permission before you prosecute a public servant. What is that provision? What does it really say? And do you think that in a way is shielding the public officials as of now?
Yes, it says that you need permission to before you prosecute. However, there have been judgments which said that, okay, you need permission under Prevention of Corruption Act. But if there's also parallel cases registered under IPC and your case is still at the special judge's place, it has not gone further up, you don't need permission. You go ahead and try in IPC. Yes, there is a restriction that the trial has to be done in minimum 2 years and maximum 4 years. But they said that permission, because if everybody goes by permission, it is going to cause undue delay. And permission might not come through. So
but that is only for the IPC cases, right? So for the IPC, you may not need permission, but to be prosecuted under the Prevention of Corruption Act,
yes, you do need.
Is permission mandatory or not?
Permission, so far it has been said, is mandatory because
So
the amendment
on
has
what
been done.
stage? At what stage is it mandatory?
It is at the special judge's stage. At the stage of trial, it is mandatory to have permission.
So which means that before the prosecuting agency goes ahead and files a charge sheet,
Right.
it needs permission.
It needs permission,
it needs permission from the public servant's immediate boss, or is it supposed to be like the head of that particular division?
Head of the division, right.
And does the law prescribe any time limit for the permission to be sought or for the permission to be granted?
Yeah, that becomes an issue because often the permission is not given. And then it will go further into appeal to another court, because see, permission time limit is not there as such, but trial time limit is there.
In the special law only.
Right, in the special. So that kind of puts you in the
so
issue.
Are we trying to say that there is no time limit even for the prosecuting agency to ask for permission? And the department which is supposed to give the permission, there is no time limit prescribed for them also?
There's no time limit as such prescribed for it. But as I said, for trial there is a time limit. So it kind of, bounces both ways.
Okay.
Right.
Okay. Prachi, next question would be, how is corruption defined in the Act? What is the meaning of corruption? Is only accepting bribe, is it corruption? Or is it asking for bribe corruption? So how is corruption defined?
So corruption it's defined in 3 ways. First is to asking for bribe, which is again not called bribe. It is still called undue advantage.
So bribery, the word is undue advantage in the law.
You will see undue advantage. Bribery is mentioned only couple of times in Prevention of Corruption Act 1988. Secondly, if you are giving, that is also corruption, and the punishment even for giving is 7 years. And if a third person is forced to pay bribe, that is also corruption.
Okay, so there are 3 forms of corruption.
Right.
Okay.
And the thing that a lot of people that I personally know have requested that should, be included in it is, as based upon the Bribery Act of UK, that just a request for bribe should also be counted as corruption. That if a person has requested, no action has happened on it, but that request should also
So how is that different from asking for a bribe? Because you said asking is also corruption in Indian law.
Asking is corruption, but then you have to prove it by evidence. But in UK laws, it is the burden of proof is not that much, and it has been suggested that some things can be borrowed from there.
Oh, okay. So, but which means, so does it really mean that even if the transaction is not complete,
right,
it would still amount to corruption?
Yes.
So it is not necessary that
not necessarily, right?
No,
because see, then they also transaction is not complete. There is one instance where a transaction is not complete.
Right.
However, a person might have done such acts in the past, and that is where the amendment came, and they said disproportionate assets.
Okay.
Right.
Okay.
That's when it came that this is also going to be part of corruption.
Okay.
They increase the ambit, because if otherwise it will just be based upon one act.
Okay.
And they won't be able to.
So that's my next question was around that only. When we talk about gratification, does it only restrict to money, in the sense cash, or does it go beyond that also?
No, that is why the word they said, not bribe, undue advantage. Whatever you are asking for a favor, you are asking for an air ticket, you are asking for tickets to a cricket match or anything. So undue advantage becomes, subject to interpretation or whatever can fit in it. It will go beyond anything materialistic.
Okay.
That we can, anything quantifiable, estimable, we have to go beyond that when we're talking corruption. Even favors, say, asking for your, there's so many officers who ask for favors for their children. That will also be part of it.
That can be covered as part of corruption.
Right.
So you also spoke about, bribe giver.
Right.
I mean, the law doesn't protect a bribe giver. What does the law really say about the bribe giver?
It does protect if after giving, within 7-day period, you go and complain.
Okay.
Then it will protect you. If you go beyond 7-day period, it will not apply the same way. So yes, that amendment came to protect the bribe giver. Otherwise, the bribe giver will not, if they're going to be accused and treated equally like the other accused, why would they go and
So you will not get complaints.
Right, exactly.
So, I mean, if you can just give an insight into why was this amendment really brought about? Were there complaints that were made to the government that, bribe givers are being prosecuted? Why did the government think about
Because there
bringing?
was more hesitation on the part of the bribe givers to complain, because they would be immediately put under, earlier it was okay, both of them are going to be treated as equally accused, because, promoting, you're abetting to the crime. But they realized that they need to give a little time period. It would not be an indefinite time period or a 1 year time period, just 7 days. If you have, this act has happened, within 7 days you complain to us, so that there are more and more cases that come, that are brought forward, that these cases of, corruption happened, or the bribe was asked and it was given, the exchange happened. And in that 7-day period, it is also, if there's an estimable or a materialistic amount, that can also be found.
Right. Okay. Since we're talking about amendments and the procedure for prosecution, there was another amendment brought in 2018 as well, asking for approval even before inquiry or investigation. Could you talk a bit about that, please?
Right. There was that you need to have an approval before you do an inquiry. And this is the one that we had, the section 17A, where it was like whether it will be retrospective. Say there was that complaint which was done before that came. The complaint was done in 2017 and the act came in 2018. So whether it will be retrospective or we will take it from the date of complaint. So that is of course been referred to a larger bench, as we know. But yeah, that was just done so that an approval is sought and then the inquiry happens. Because see, without approval, again, it cannot just give the bribe givers or people the authority to just keep accusing people. Approval is necessary. Otherwise, there will be too many corruption cases, false, and there will be too much trial going on, and then it will be proved. That will take too long.
So it's like a 2-stage approval, is it? One before the inquiry and one before the charge sheet is also filed. It's a 2-stage thing. Okay.
So, when you already had the provision to take approval before filing of the charge sheet, why was the need really felt to take approval even before starting the inquiry?
Yeah. See, the need for approval before starting the inquiry is also to safeguard the interest of the public servant to some degree, because see, oftentimes there might be jilted people who needed something done and it is not done, will go and put a false complaint, because the moment an act comes, it becomes a double-edged sword.
Okay.
People are, of course, going to misuse it, and misuse happens all the time. I'm not saying that every person against whom a corruption case is filed is actually corrupt.
It could be, it could to avoid any instance.
Yes, otherwise, and forget about being at the top level, it will, the effect of such things at the lower level is worse.
Okay.
Because there are also not a lot of people who are in the government jobs are not even aware of their own rights.
Right. So, is there any provision in the law which also, treats a habitual offender separately? Is there anything in Prevention of Corruption Act?
That's a very interesting question. I'm not quite sure about a habitual offender, but I'm thinking if there's an habitual offender, it might, with misappropriation and all of that. But yeah, that's a very interesting thing. I've not thought about habitual offenders.
No, but in the sense, but is there any provision? Does the Prevention of Corruption Act really talk about dealing with a habitual offender, somebody who is constantly asking for, undue advantage? Or
there must be, if there are multiple complaints, then they would of course look at the history of that person, because they keep a record of it, right?
Okay.
The departments keep it in whatever the logs they have.
Okay.
I don't know remember the exact term they have, but yeah, so that must be there, right?
Okay. Let's talk about punishments now, maybe. So what happens after the prosecution is complete and a person's found guilty? What sort of punishments does the law provide?
See, the punishments in the latest amendments are basically from 5 to 7 years, both for public servants and, somebody who's giving the bribe, or somebody who has been made to pay the bribe will be 5 years, and they will be fined. And of course, there are cases where they have been suspended or removed from the work, and then of course, then we are just talking public servant as in a government job, but also politicians, then they will be removed from their,
so at least a disqualification.
Disqualification happens, so they will be removed from their office, and those things are happening. And then of course, if you're talking, say, about chairman of a, para board, which is not completely government, but it is run, in confluence with the government. So they will be also removed, actions will be taken, those things happen. So that is the kind, but the punishment doesn't go beyond 7 years.
Okay.
Right.
Prachi, I just want to ask you another question related to sanction. What if the government or the department where the alleged public servant who's accepted the bribe is working, what if the government or the department refuses to give sanction? Then what happens? Or can the government or the department say, no, we will not give you sanction to prosecute so and so?
Right, they will.
So can they do it? Can they do it?
They do that all the time.
Okay.
And then, you move to the next
So
authority.
what is the alternative or the remedy with available to the prosecuting agency? Suppose the government or the department says we are not giving you.
You go into appeal to the next court.
Okay, so you can challenge that decision.
You can challenge that, of course.
And if a government has to deny sanction, are they supposed to pass any speaking order, or can they just deny it in one line?
They have to give an order. They have to give the reason for denying it.
Okay.
That is, to my knowledge, the cases that I have come across, I've always seen there have been reasons for it. So that, whenever a prosecution agency is going into appeal to, say, the next higher court to get the permission for the same, they have a reason.
So, are there any judgments around this particular subject, where sanction denied by the government or the department has been set aside by any court for?
Right. There was this 5-bench judge bench. The Supreme Court had held that it was the PC Act and IPC one that I was saying where the sanction was denied. So special courts it was denied. Again, High Court it was denied. But they kept allowing it under IPC.
So you mean to say that you mean to say there were parallel proceedings going on under the IPC?
Cases were registered under PC Act, IPC, and some more acts. But they said that since the IPC is there, we will allow investigation under IPC even if Section 19 of PC Act is left alone. So they kept giving permission, and then the appellant went to Supreme Court and they also said it's okay. Even if there was no permission granted, the investigation went on under IPC, and we are not going to say that you cannot go ahead with the investigation. And one thing that brings to my mind was that we forgot that PC Act is one of the few acts in India which has an extraterritorial jurisdiction.
Okay.
Because there are very few, and NDPS of course has it, but there are very few acts that have it.
Okay.
And PC Act is one of them.
And can you just explain it a little bit further?
So if corruption has happened, so extraterritorial jurisdiction is if the person's crime is related to any act outside of India. So they can again be tried in India. If they were tried and given a punishment by a court outside, they can again be tried back in India and given the punishment, and it will not count as double jeopardy.
Okay. So that protection is not there under the prevention of corruption.
No, and that was anyway needed because PC Act is again related to PMLA in so many ways.
Yeah.
So all these, when they come together, they needed they needed help from other agencies outside also.
Right.
To know about assets, to know about technology, there's a lot of input that is needed when corruption is happening. We're living in a times where you come across one PC Act case and then it is linked to IPC, then it's linked to PMLA, then there is cryptocurrency.
There are a host of other offenses also that come into play.
Now with crypto and all, it's like white collar crimes are very complicated.
That's right.
It's like a well-oiled machinery.
It is now becoming, right?
In that sense.
Yeah.
So in this well-oiled machinery, just before we end this show, do you think, and it's been over 3 decades of the PC Act,
right?
In your experience, how efficient do you think the law has been, and do you think there need to be more changes on the ground or in the law to make it more efficient?
It needs to be. I think we are not well equipped. We don't have enough people to run an investigation smoothly. There's not enough funding to run investigations. There was a very interesting case in Delhi High Court about it's related to corruption and PMLA, and then said, okay, we can't finish the investigation because the accused is not giving the password. Okay. So you cannot ask password from the accused. That was held. That is self-incriminatory.
Right.
So the agency should have the technology or access to technology to decode it.
Right.
For speedy trials, for speedy... there are lots of disruptions. First, you might not get an approval. You might not have the funds. You might not have the tech support. You might not have enough team members in investigation agencies. So yeah, there's a lot of gap that has to be filled in. And as and when new technology comes or new challenges come, there is a new amendment. If it's not an amendment is not there, then there might be a judgment that comes that acts as a precedent.
Right. Okay. With this, we've reached the end of this episode. In this episode, we spoke about the Prevention of Corruption Act and how it's a part of this larger, well-oiled machinery to curb corruption in the country. Of course, as Prachi mentioned, there's a lot more that can be done as well with amendments or with Supreme Court judgments that interpret the law. I hope you enjoyed this episode. Thank you so much for watching.